I'm Ravi Chandrapala from Armchair Criminal. This is the third part of a four-part series on unavailable witnesses. As the topic suggests, we are dealing with unavailable witnesses and the problems that is caused because of the unavailability of a witness. In this particular part, I will look at, in particular, the procedural points with regard to that. There is an overlap with certain other aspects of hearsay evidence, which I will deal with in due course when I consider such topics as Section 114, the safety valve or the flexible friend, res gestae, and human rights in the light of hearsay evidence. For these purposes, let me start off the discussion by considering if any of the conditions, the gateways, in Section 116, subsection 2 are met, is the hearsay evidence is automatically admitted. I would say that there are at least 2 points to consider here. If only one condition is needed to establish, to trigger Section 116, subsection 2 situation. That's the first point. On the face of it, this is the second point. On the face of it, if any of the conditions in 8D are met in Section 116, subsection 2, it seems that hearsay evidence can automatically be admitted. In that, what I mean is, provided that you meet the criteria listed in those A to E, judges' blessings are not necessarily required to admit the evidence. However, it is unlikely that hearsay evidence to be admitted that easily in the light of the cases of Horncastle and others, and then the well-known cases of Al-Khawaja and Tahiri. Talking about Al-Khawaja and Tahiri, whilst I have given that citation, there's a 69-page law report of the 2012 Volume 54 Human Rights Reports, starting on page 23. They are important cases. We will be looking at them in somewhat detail. What it means is this. In fact, there's a very good dialogue between our courts in the English jurisdiction and that of the European Court of Human Rights. Initially, the European Court of Human Rights came against our jurisprudence. However, the cases Al-Khawaja and Tahiri both ended up in the Grand Chamber. There was the case of Horncastle, which is the leading authority. And finally, the European Court of Human Rights accepted that we have a very developed system to ensure that hearsay evidence under these circumstances, i.e. unavailable witnesses, will only be admitted where it is safe to do so. Therefore, accepted that unavailable witnesses' evidence is not always automatically disallowed. There are instances where the courts can admit unavailable witnesses' evidence safely. The next question that I'm going to look at is, are there any safeguards to ensure the safety of the statement before it is admitted? The short answer is yes. We have a fantastic developed system to ensure that the evidence to be admitted is checked, scanned, and it is only admitted if it is safe to do so. That is why the Supreme Court in Horncastle was able to justify our jurisprudence and get the European Court of Human Rights to agree with our system. In order to consider that concept, one must understand that those of the Crown wishing to admit hearsay evidence of an unavailable witness, how to prove their point to that very high standard of criminal courts needing to be sure that the material is to be admitted is safe. We'll look at a few cases. Let's look at the case of Shab. The full name, I think, it's Mohammed Hanas Shabir. The facts were this. The case involved a case of allegation of murder using firearms, and there was a witness. In fact, there were several witnesses. Some of them became hostile witnesses. A man by the name of Ravi refused to give evidence, claiming that he was in fear, not only for himself, but for his family. There came a need for him to be seen by a mental health doctor who said that he is able to give reliable evidence, and in fact, he was to give very important evidence with regards to the identity of the shooter. He refused to leave his prison cell to attend court to give evidence because he was in custody for other matters. Then the officers attended and took a statement from him, in which he said, I have had difficulties in the prison. I have been assaulted. People have been calling me a grasser. And he said, what I have stated in my statement is factually true. In the light of this, the Crown made an application to adduce the evidence under Section 116 of the Criminal Justice Act 2003. Needless to say, the defendant objected to it. A voir dire took place where the officers gave evidence as to the fact that they went and took a statement from him saying that he does not wish to give evidence. What he has said is true. And the officers said, in that case, your original statement would be read. Now remember, it was in the case of Horncastle, I think it was paragraph 87, if I recall correctly, that the court said such promises, indications should not be given. And the matter went into the Court of Appeal. The Court of Appeal considered the legal framework and said that special measures could have been put in place for Ravi to have given evidence. The Court of Appeal was critical of the witness being told that the statement could be read. As I said earlier, the Lord Justices were referring to the case of Horn Castle. Because what it does is actually undermines the evidence. Under Section 116, Rafiq's evidence was important to the extent that it went to the identification of the shooter, and he was able to give reliable evidence. The court also expressed their concerns as Rafiq's mental health and his previous list of convictions and some inconsistencies in his evidence when he was arrested in 2009. Albeit that his identity of the gunman could be reliable. The Court of Appeal said that the prosecution has failed to establish their application to the higher criminal standards as to why Rafiq refused to give evidence. Therefore, his conviction was quashed. The next case is the case of Matty. Here, the facts were that an affray took place. Two witnesses who saw the incident gave statements, but they lived in France. After witnessing and giving the statement, they returned back to France, understandably. The defense in this case tried to have the statements in on the basis that it is not practicably reasonable to get hold of them. There, the Court of Appeal dismissed the application on the basis and said that whilst accepting the Crown has more resources than the defense, but nonetheless, they also have a responsibility to take certain steps, and accepted that in their case, their responsibility to prove the case on this particular point is on a balance of probability. What is equally important to note is Section 116 subsection 2 spells out the safeguards generally that is applicable in these instances. I'm talking about A to D here. I'll look at E later, because if E is applied, then there is an obligation to seek the learned judge's permission. Equally, Section 114, subsection 2, still applicable, the safeguards in that. Where there is a concern, the trial court has the power to exclude the evidence under Section 78 base and Section 126 of this Act. Equally, the judge has the power to stop a case where the evidence is not convincing. It is interesting case to look at the case of Jones. Here, the allegation was quite simple: actual bodily harm, and there were two counts on the indictment, and there were some injuries. The defense case was that he was attacked and he was basically acting in self-defense. He was remanded in custody. During this time, the complainant wrote a letter to him, basically saying, come back home to reconcile. He was eventually granted bail. There was no allegation of him interfering with the witness. 3 days before the trial, the police attended her house to ensure that she's coming. They had some concerns that she is reluctant, bearing in mind she has given a withdrawal statement stating that she does not wish to come to court some time ago. Then, despite the concerns the officers had, they have done nothing. On the day of the trial, the defendant attended court. Not only that, the complainant's father attended court with him. And the information got to the prosecution that she is not at court. They made an application under Section 114. The judge was not referred to Section 116. Therefore, the judge considered the balancing of risk factors to admit or not the evidence, and the judge was not invited to hear from the police as to what has taken place. The judge considered the situation and asked himself the question whether overall evidence of the statement can be given. If not, why not? Subsection G, I do not need to deal with that. After that, the trial proceeded and he was convicted. What the Court of Appeal said is this: when he was convicted, Court of Appeal noted that there was no suggestion that the defendant had been responsible for non-attendance of the complainant. So that is important. He has not played any part in it. The Court of Appeal also noted that there was no suggestion that the defendant had not been responsible for the complainant. Non-attendance is not the only point. The officers have not taken steps knowing that there was a welfare issue and the complainant may not come to court on the day of the trial. They could have considered the possibility of special measures. They could have gone to her house on the day and encouraged, even possibly given a lift. Therefore, the Court of Appeal felt that there was lack of due process in this regard. The Court of Appeal felt even if the defendant's case is fanciful, because of the failures on the part of the prosecution, namely the police officers, to deal with this situation properly, that the defendant was denied a fair trial. Therefore, you now should notice how this is developing. I will quote from paragraph 19 of the judgment. It says this: we stressed that there will be many cases of domestic violence where it may become inevitable and absolutely necessary for a court to ensure justice is done and to admit the statement of the complainant. In such cases, it often will be the case that the complainant is the only witness, but this in itself is not a good reason necessarily to refuse such an application. What we do stress equally, however, is that if such an application is to be made, it should be properly based. It should be properly evidenced. And the court has a responsibility to properly investigate the matter. We regret, in this case, that investigation does not appear to have taken place. We cannot be satisfied From the transcript of the ruling that the judge did take into account appropriately all matters concerning this complainant's absence. No, take all necessary steps as would ensure her welfare and the fairness of the trial by obtaining her attendance. Therefore, you would note that not only the prosecution in that case had an obligation to investigate why the person is not there and to put things in place for the person to attend court, either through a video link or physically. The judge has a duty to investigate the matter further. Let's look at the next slide. Even if a condition, i.e. a gateway, under section 116 are not met, can the court still allow hearsay evidence in? The short answer is yes, very easy. When you look at section 116, even might overlap with not only with section 114, but with section 117, such as business documents. In fact, that is what I'm covering on the next slide. The authority on the point for that is Foreward. The next important point that I would like to look at: can multiple hearsay evidence be admitted under section 116? Truly speaking, my understanding of this section, it is silent on the point. Therefore, there is nothing to suggest that it cannot be. However, the more the number of anonymous witnesses are there, the case becomes weaker to argue that multiple hearsay should be admitted. As we know, that hearsay evidence inherently is a weak point, because that is second best evidence, as we always keep on referring to. So if that is repeated several times more, it becomes weaker and weaker. Therefore, I doubt very much, although in theory one could argue that it would be allowed. If, on the other hand, if the maker of the statement's identity is known, then it begs the question, why a statement not being taken from that person? Why is that person not here? So, whilst it is theoretically feasible, it is not necessarily sounds very good to argue that point. However, section 121 allows multiple hearsay to be adduced from an earlier statement. Therefore, section 116 covers multiple hearsay that would have been available to be adduced under that provision. Next, this is actually a new topic in itself. What are the gateways that would allow unavailable witnesses' evidence to be admitted? There are 5. One is death. Second one is illness, unfit. It could be physical or mental. Third is unavailable, cannot be found. Fourth, out of the jurisdiction. Fifth, fear. Let's look at them in turn. Okay. If it is a case that the application is based on death, the witness is dead, then I would have thought It is fairly straightforward. Depending on the circumstances, the evidence would be adduced. Now, what comes to my mind at this juncture is a classic case of res gestae, a dying declaration. Let's look at the case of Chandrapala, for example. There was the victim whose throat was slit, came out of the room or wherever she was, and said, basically gesticulated to say it was Chandrapala who was responsible. Now, that person is dead. But that is a very piece of powerful evidence that would be silly to exclude simply because, sorry, that person is not here. So there are circumstances. Equally, I will explore this topic in detail when I'm looking at res gestae, where the victim or the complainant is available, makes a statement, allegedly, soon after the incident, but doesn't want to give evidence. Is it reasonable then? I will look at them when I'm looking at res gestae. Next point is unfit to attend court because of illness. Now, there are two things. A person could be unwell to attend court because of bodily condition, physically unable. Or the person could be unfit because of psychological problems. In such situations, who decides whether the person is unfit to attend and therefore cannot give evidence or not? It is the judge who would decide whether that condition is satisfactorily established. Because it's a point of law. Yes, the learned judge, the court will take into account any evidence from doctors and other experts to say whether the person can give evidence. Here I'm going to look at a case by the name of DPP and McQueen, and the facts are that this was a case that was in the magistrate's court. Simple allegation of criminal damage. 2 children witnessed the incident. The defendant didn't cooperate with the interview, basically, and there were several aborted hearings in this case. The Crown Prosecution Service wrote to the police to confirm whether the person is fit to give evidence. That they provided basically evidence from the witness's doctor to say that he suffers from digestive problems and his condition could be worse if he is put on an obligation to attend court because his anxiety might be raised. And as for the second person, he was merrily and happily working in a McDonald's. So none of them came. The Crown applied for another adjournment. That was refused. They made an application under Section 116 to allow the evidence. The justices instead allowed the evidence under Section 114. The defendant was convicted and he appealed. The administrative court held that Section 114 should not have been applied because Section 114 is designed not to overcome problems of this nature. That is why it is called the safety valve, not the convenience valve. And here, the court found the reason the magistrate's court allowed is basically to overcome a problem the CPS has. And in giving that judgment, the court looked at several things. The court accepted that there had been a number of adjournments attributed to the Crown's difficulties, the regular attendance of the claimant and the appellant at all hearings. Then there was a failure on the part of the prosecution to explore if there had been any CCTV coverage of this incident. The Crown has not obtained any evidence with regard to his mental state, namely the issue of anxiety. They have also failed to consider the possibility of obtaining evidence by means of special measures, like a live link. The person could have stayed at home, given evidence from home on a live link. Also, the court noted there has been a failure on the part of the Crown to make an application and give notice. Therefore, the administrative court felt that they have no option but to allow the appeal and quash the conviction and the sentence. Then there's the authority of Bennett. This was a case that was heard with the case of Wright, and it involved a nurse accused of assault. The prosecution made an application to adduce the patient's evidence. He was convicted and appealed. There, the court felt that the statement was correctly admitted, because the court thought the trial court not only considered whether the patient could be brought to court, but whether she would be psychologically fit to give evidence if she was brought to court. And equally, that the defendant should be given an opportunity to cross-examine the doctor who testified that the person is unfit. When you look at the case of Elliot, you would note that author. Elliot, I may not have given the citation. It's 2003 EWCA Crim 1695. Also, the court also recognized that the judge should consider what is the prognosis. Is the person likely to recover? Then, under section 123, the court should take into account the statement maker's mental capacity at the time the statement was made. It is generally thought if the person is bedridden, then the chances of that a person of that pain and suffering would be regarded as being unfit to attend court and give evidence. But it doesn't necessarily mean that the opposing party cannot argue that special measures could be put in place, like a live link. It is a question of fact. So whether the person is able to give any form of evidence will depend on each and individual. It will always be fact specific. Then also the court would consider whether by attending court the witness's condition would it deteriorate. That is something which should be looked at. There are a couple of other cases called Crown and Meredith Harwich justices and the second case of Uxbridge Magistrates Court. In the case of Harwich, in order, it was an allegation of careless driving and failure to stop after an accident. He pleaded guilty to careless driving but not to failure to stop. There was a witness who supported the prosecution case. And at trial, the prosecution provided a statement from the GP of the witness to say the witness suffers from anxiety and it would be best for the witness to provide a written statement. The Crown sought to adduce under Section 116 the statement and the defence objected. However, the justices allowed the statement to be read as they considered the objection was not in relation to 116. The defendant was convicted and he appealed. The court allowed the appeal on the basis that it is correct that the defendant should have objected, and the court also has a duty to ensure that valuable evidence is admitted and the fairness of the defendant. GAP's statement might have been grounds for an adjournment, but that did not go far enough to say any more. The court also recognized that they should have considered the possibility of live links. And it was for the Crown to prove beyond reasonable doubt that the witness is unwell to attend court and give evidence physically and or mentally. On the other hand, in the case of Crown and ex parte Uxbridge Magistrates Court, this was a case where it was an allegation of assault. There the complainant, again arising out of a domestic situation, complainant failed to come to the court to give evidence. The prosecution sought an adjournment, but that adjournment was denied by the justices, claiming that it was not in the interest of justice to adjourn the case. And they gave no further reasons as to their decision. Therefore, the prosecution was, in essence, forced to offer no evidence, and they appealed. Yes, it is correct. The court said that the authority of Picton says that adjournment should be granted not each and every time one is made, but in exceptional circumstances. However, there's an overall obligation on the part of the court to ensure that the innocent person is acquitted, the guilty are convicted. The court has the power to grant adjournments, but they refuse to do that. Therefore, the court felt in this instance that the justices were wrong to have denied an adjournment and quashed the acquittal, and ordered basically a retrial. The last case that I will look at under this heading is the case of Hamburg. The defendant was to stand trial with his co-defendants for importation of drugs. And the Crown was to proceed against the defendant they were relying on evidence where there was a difficulty with the defendant who was struggling from angina. In fact, he had been taken to the hospital on several occasions. Then eventually came a point he refused basically that to give evidence. He was convicted and he appealed. The Court of Appeal held that the judge was bound to have considered that although the defendant was absent involuntarily because of his ill health, but was able to take the advantage of Section 116 and 114 and other special measures. It was his right not to advance his case, a positive case. Therefore, the judge was correct to hold that this was a rare case where the defendant was involuntarily absent. Maybe I should correct when I said that he refused earlier. It was involuntarily. But still, through his counsel, that he was able to have a fair trial. So you would note now, it is not a clear-cut case that each and every time a person is unavailable, that Section 116 will succeed. It depends on various factors. I'm now going to look at the next two headings together. That is the condition C and D, where the witness cannot be found and where the witness is out of the jurisdiction. Here, you would note that condition C says outside the United Kingdom and is not within red brackets, I have highlighted the point, reasonably practicable to secure his attendance. Condition D, again, reads as that the relevant person cannot be found, although such steps as it is reasonably practicable to find him have been taken. Again, there I have highlighted the important words, reasonably practicable. That is the operative word, phrase, reasonably practicable. What is the implication of this commonality in C and D? When you look at the case of Henry, it basically explains the situation. The facts of the case was that it was a murder case, and he appealed on the basis that the judge should have found there was an abuse of process for failing to have one of the witnesses available at court to cross-examine. And the witness A in question had given two statements, and there was some contradiction. In essence, the defendant was linked to a murder by a testimony of a witness called Malcolm and finding defendant's DNA. Defendant gave an interview where there were contradictions. On the day of the PTPH, defendant requested witness A to give evidence. And so far as the prosecution was concerned, he was not an important witness. The defense case statement was served, and that caused the Crown to make inquiries. It was transpired that the witness A was deported as he was an overstayer from the West Indies. Inquiries were made and eventually traced his aunt's address, where the police attended but was unable to trace witness A. It was during the trial the importance of the witness A came to be highlighted, as he was being accused as one of the suspects in the case. The judge refused to stay the proceedings on the basis that the Crown has failed to take serious steps to find the person and the police should have persuaded the immigration authorities not to have him deported. In deciding this case, this is what the court said. In determining what steps it is reasonable to find a person who has made a statement, it is relevant to have regard to the relative importance of the witness as well as police resources. We suggest that this is obvious. We do not understand Mr. Millington's to contend otherwise. We observe that there is support for this proposition in the decision of Crown and Coughlin, 1999, 5 Archbold News 2, a decision of this court. The principal and fundamental criticism of the police made by Mr. Millington is that they allowed the immigration authorities to deport dashing before the trial at all. As we have said, he was deported on the 23rd of March, several weeks before he was ordered to be fully bound as witness. What it implies, the implication of is this: what is needed to be done is to take reasonable, practicable steps. You cannot expect to do anything beyond that. The prosecution were not to know when he was deported that he was going to be an important witness. And thereafter, they couldn't trace him. The next point is, what is meant by reasonable and practicable to persuade the attendants of the witness to give evidence at trial? Here, this is a question of fact. It will depend on each and every case, the circumstances pertaining to that. What is reasonable efforts were made by each party to secure the attendance of the witness. In essence, what the court looks at or at least the court will look at, is what steps, if any, were taken and could have been taken by the party seeking to rely on the hearsay evidence to secure the attendance of the witness at trial, and if there were other steps that could have been taken in order to adduce the evidence from the witness that could have been taken but not followed through, such as special reasons, why not? And the judge will look at the circumstances of this situation. What is significant is the next is how is the measure of reasonably practicable is considered. What steps, which we looked at, and one of the cases that I think we should look at is under the question of what is the significance of the judge being told that the witness cannot be found, is very important authority of Shah. It's called the Crown and Shah Sultan. The case involved a large scale of importation of drugs from Pakistan. There were several witnesses. One of the key witnesses was a man called Doctor. And the defense case was that he was not involved in bringing drugs. He thought that he was bringing in, basically, some illicit homeopathic, Ayurvedic medication, nothing to do with class A drugs. And the matter went to trial. The court had a PTPH hearing and the witnesses were ordered. Several pieces of communication took place between the prosecution, the CPS, and those who were working with this man called Doctor, the undercover agent. And at times, he was regarded as being even unreliable. To the horror of the defense counsel, on the day of the trial, he was told these witnesses are unavailable. 3 of them, in fact, if I recall correctly. And the defense wanted them. What the prosecution did say is the fact that they are not there is only weakens their case, the prosecution case. So what's the problem? Because they are unimportant witnesses. From the point of view of the case, if they are important, in fact, it will only damage our case. The judge was also told, we have done the best we can, basically. We have been told that the witness cannot be found or unavailable. The trial proceeded. During the trial, just before the close of the prosecution case, this man called Doctor came to the notice of the police. He said, these are my details, the same details that the police had on him in their file all the time. Not only that, he said another person who can give evidence is in England. Nothing was done. The defendant was convicted and he appealed. Then, in the Court of Appeal, it came to light what has happened, and the Court of Appeal, very correctly, if I may humbly say so, that the court found, by telling the judge that these witnesses cannot be found, is to mislead, when in fact they have done almost nothing to trace him. Even when he came to their attention, they did nothing. Therefore, it is important to be precise what is being said to the judge. Otherwise, the judge will base the decision on what is being said. The next part is with regard to what could be the competing factors to determine reasonableness. Here, you look at various factors. The factors that one would look at is the seriousness of the matter. You would treat a case of simple shoplifting very differently to a case of serious allegations of murder, rapes, and kidnapping. However, in my view, what is reasonable not only depends on the facts of the case, it could depend on the impact that it could have on the defendant. You imagine a young man being accused of say theft. What does he want to become? Or a lawyer? Or an accountant? Imagine what the professional bodies will see in this candidate. Or an assault on a young medical student. Consequences will be huge. So you need to, I would argue, that not only the facts of the case, but it is important to look at the person. Then how serious the allegation is. Yes, I accept. A murder case will be very different to a shoplifter. How important the evidence to the case. How prejudicial that will be to the defendant. What are the steps could have been taken to adduce the evidence? such as live links. I have given the authority of E, but I'm not going to go into details on that. Equally, there are other cases such as C, Rate, DT, Jones, U and E, which will describe what is the approach that is taken by the courts with regard to what is reasonably practicable. It is important to note that those cases really highlights the point that I'm driving at. Finally, I come to the question, is there a legal mechanism to get witnesses from abroad to come and give evidence in this country? Unfortunately, there isn't. There's nothing can be done, at least I know of, to get a witness from another country, save for offering live links, encouraging the person, or possibly even paying for the ticket. But it is not that easy. In fact, it is not possible to force a person who's outside of the jurisdiction. That is all I intend to cover at this stage. The penultimate part of this series will be the next session, where I will look at unavailable witnesses through fear. I hope this part of the program has been useful and that you found it interesting. Thank you very much for your valuable time. Take care and God bless.